One of the biggest things that is happening in the estate planning community right now is that there's going to be this tsunami of work that's created as the baby boomer generation ages out. And we know that that's everything from planning for taxable estates, because there's also a sunset of the estate tax exemption, the exclusion amount. We know that unless there's some new legislation, it's going to go down. And with the baby boomers aging at the same time, it's a great opportunity to do some very tax efficient planning for them. But there's also other planning that comes about, whether it's Medicaid planning, let's say they don't have a taxable estate, or, it's incapacity planning. There's so much going on there, and we're going to see a lot of work for estate planning attorneys in the coming years.
A recent trend or development that I see that estate planning attorneys should be aware of is beneficiaries moving retirement assets and using the wrong method to move it. For instance, if you inherit an IRA and you're a non-spouse beneficiary, the only way to move it and retain tax-deferred status is as a non-reportable trustee-to-trustee transfer. But I'm seeing individuals, they get impatient, right? Because when you use a transfer, it takes time. It may take a couple of weeks, but they get impatient and they're thinking, I want to move the money now. So I'm going to where it is. I'm going to ask for a distribution and I roll it over within 60 days. No, you're a non-spouse beneficiary. You cannot roll over a distribution. The only way to do it is as a transfer, and you initiate that on the receiving side of the transaction.
I'm not so sure that this is a future development in terms of it being something new that estate planners have to be aware of, but I think an often overlooked part of planning is implementing the client's real objectives. We oftentimes have a tendency to focus at if an individual has a taxable estate, there's a certain menu of strategies that they need to be using or that a smart client would be using in designing their plan, without giving a whole lot of regard to what are the non-tax aspects of working with this client. A lot of people are going to try to talk clients into making very large gifts to take advantage of exclusion amounts before they sunset. But if a client is not comfortable making a large gift, they shouldn't be pressured into doing it. A client should only be giving an amount that they're comfortable giving away, even if tax considerations had no involvement.
The big thing you need to be conscious of going forward is that all of these decantings, reformations, commutations are not tax-free. You have to walk around the problem. So if you're going to do a decanting, a reformation, or the commutation of a trust, you have to walk around the problem and say, what are the income tax issues? What are the gift tax issues? What are the estate tax issues? And what are the generation skipping transfer tax issues? I think that's the next wave, because for the last decade, we've approached these reformations and commutations, decantings in a very almost cavalier way, that we could do them without income tax implications, without estate tax implications. And that's not always true. So walk around the problem and look at everything that's out there from the government, what the government has already telegraphed. So every time you see something like the CCA or like Antenberg or McDougall, that's just starting to paint this mosaic of how the government is going to look at these transactions.
So I think one development that every attorney, regardless of your practice area, needs to be aware of is AI. The incredible growth of the capacity of artificial intelligence and the incredible growth in the ways that it can be used and in the understanding that's required to manage it responsibly. Okay, so I think that AI presents an enormously exciting potential, and it also presents a real challenge to all practitioners to ensure that they become appropriately versed in its ethical use across whatever discipline they practice.
The most significant thing that's going to change in 2026 or at the end of 2025 is this essentially sunsetting of the current estate tax exemption amount. And so there's a lot of planning that needs to go around that. Even if it doesn't sunset, one of the things that caused a lot of attorneys to shift to was asset protection planning for the next generation. So instead of just looking at the current tax structure or tax issue for the client, you're looking at who are they giving their money to and how can we protect it from their creditors and predators. So it just depends on what happens with that estate tax exemption amount. And if it sunsets, there's more opportunity to have to plan for this generation rather than the next one.
The most significant element in estate planning that I see is that
there's this multidisciplinary practice coming right at us. I think Arizona, some other states may already have it, where non-lawyers can own law firms. Well, when we get to that, what we may have one day is some of the big investment houses, some of the big trust companies saying, we'll do your estate plan for free, just put your money with us, because a lot of the real money is in managing the assets. So how do we compete against that? What do we do as estate planners, or how do we work with that? In that sense, we have to become much better at technical advice for our clients. And I also believe that we have to have an open attitude of collaboration with financial planners, with insurance agents, with CPAs. So up our game as far as it's concerned with our knowledge, skills, and experience, and be open to collaborations.
Well, definitely the sunset's coming next year, so there's a lot of tax planning that needs to be done. And my dad, a lot of my clients come from my father, who's a CPA. So having the access to understand GRATs and SLATs and all the other the alphabet tools has been something that I can go back to talk more intelligently about and to be more conversant in those areas with my clients. So I feel like it's been, those are probably the most important things that I'm looking out for as exclusionary, possibly sunsets next year.
Another area of development is handling digital assets in estate planning, which I've been referring to as the Wild West, because the average client of ours has 250 digital assets, and many of these digital assets can't be passed on or can't be managed by others that aren't the owners. And so we're having to sort of guide our clients through how to manage them in their lifetime and pass on some of the assets that are generating income and are very valuable onto their successors or heirs. And I think this will be an ever-evolving area of the law, digital assets and passing them on to loved ones. I'm calling it sort of the Wild West because it also involves influencers who are, new. It's a new profession out there, and influencers are making tens of thousands of dollars, but their assets that derive that income, they're digital assets that can't easily be funded to a trust or passed on to a successor in interest. So we taught about that this year, and I know that we'll have more sessions on it in the future.